Today we have a great panelist, and what we're going to do is start the panel discussion, and as we do every month, we're going to leave a portion at the end for updates from all of you that are attending or other questions that you might have, and then share some updates from those from across the state. So I have the pleasure now of introducing Jen Randolph Riza. She is a business law professor at Mitchell Hamlin School. I need a little bit more coffee here. Of law, and an attorney at Taft in Minneapolis. She has been so gracious to help pull this event together. We talked months ago about our need in our startup ecosystem to get the right legal information for our startups. And she's like, I'll help you. This is important. And she just did this out of the kindness of her heart. And so it's been a pleasure to get to know her and for her to be able to pull together the talent today. So Jen, I'll let you introduce the panel and take it from here. Thank you so much.
Great. Thank you so much, Neela. I'm really excited to be here, and I'm really excited to introduce these other three wonderful lawyers who are going to speak on a panel with me to your startup community. This was really fun to try to put together a panel. I know that legal is one piece of the puzzle that entrepreneurs are trying to juggle, along with, the many other priorities that they're trying to figure out. And so my hope is that this discussion today will help entrepreneurs think about how to balance risk and when they need to find and pay a lawyer, and conversely, maybe when they don't. So we're going to try to, be really helpful and give you some real talk here. Before we start, though, I should just give a quick disclaimer. I hope that we have lots of good advice about legal matters generally, but obviously nobody should interpret this as like legal advice directly to you. For that, you should, form an attorney-client relationship with somebody. Okay, so there's my disclaimer. All right, so we've got a panel of 4 local lawyers. First, you heard about me. I'm Jen Randolph Riza. I'm a business law professor at Mitchell Hamlin. And let me introduce you to first Brenna Erdman, and then John Cantrill and Nick Leonard. I'm going to ask each of them to give you just a little overview of what they do.
Sounds like I'm first. I'm Brenna Erdman. I work for a private, smaller investment company, and what we do is we get in the startups themselves. So we invest in these companies, and we usually become investor owners of at least a third or more. So with that, we've been able to really get in the weeds with them, and I'm able to help them as a partial owner with their legal needs. So I've worked with, I think, 16 or 18 startups since I've been in this role in the past 5 years, and it's been amazing to see, and I've learned a lot of things. So I'm happy to be able to share some of that with you.
Awesome. John, how about you?
Morning, everyone. My name is John Cantrill. I'm an attorney with EntrePartner Law. We're located in Northeast Minneapolis. Little background about myself. I practiced in a small startup firm in Raleigh, North Carolina, doing a lot of different legal needs as far as like early stage development of companies, capital fundraising, intellectual property formation, documents, contracts, things of that nature. Our firm right now is very catered to the entrepreneur, whether that be a startup company, whether that be a real estate developer, a franchisee. We really want to, facilitate innovation and growth within the city and try to help people start off on their own venture. So happy to share experiences that I've encountered in the many different industries and things that I've worked in.
And Nick, sorry.
That's okay. Hi, I'm Nick Leonard, and I'm an attorney with Sapientia Law Group in downtown Minneapolis. A little bit about background of myself is I started out working for the large law firms. You might have heard Robbins Kaplan, and I guess Faegre is now Faegre Baker Daniels. And also I'm an entrepreneur, so I have a lot of background with startups, growing businesses, and I have some experience with large businesses as well. I'm a patent attorney, so I'm registered with the United States Patent and Trademark Office, which is a specialty within attorneys. So if you're looking for patent work, that would be someone you'd want to contact regarding that. Yes, we're our group. Now I'm with this smaller law firm where most of us came from large law firms. And so we are kind of a diverse practice, and we cater to that growing business, the startup, and really to help entrepreneurs see the potential and realizing their assets, finding ways to fund and grow their business, and handle any issues that come along the way, because we have really strong litigators as well. Thank you.
Terrific. Thanks, guys, so much. Really appreciate you being here with us today. So here's what I'm going to do. We've introduced ourselves. I've organized this panel around 4 key topics that are areas of legal need for entrepreneurs. Okay, we're going to talk about choice of entity and buy-sell agreements. We're going to talk about equity arrangements and raising money. We're going to talk about IP, and we're going to talk about contracts. Okay, so those 4 subject areas will in turn be addressed by me, Brenna, Nick, and John. All right, because those are, you know, some of the areas of our expertise, as you heard. And then we're going to leave lots of time for Q&A, because we want to hear what you guys are thinking about and tailor this to you guys as well. So feel free to put in the chat questions that you have either right now or as we talk. And I will attempt to moderate those and lead the discussion in that way as well. And we will wrap up by 9:15 to hand it back to Neela, as I have promised her already. Okay, all right. So I'm actually going to kick us off here and talk about choice of entity and agreements between founders. Okay, so when an entrepreneur has a business that is not an LLC or a corporation or some other kind of entity, you should understand that you have personal liability for business debts. That might be okay. All right, that might be worth it if you are just getting started, if you haven't taken on a lot of liability for the business. But to the extent that that becomes concerning and weighty, forming an entity in which to hold the business is the way that the law allows us to offset that risk. Okay, so what entity do we choose? Well, the LLC is obviously the sort of, oh, hello, I'll mute you. The LLC is obviously the primary choice of entity for most small businesses joining today. That's in part because it's cheap and it's pretty flexible. All right. You can form an LLC in either the state that you are actually doing business in, or another state such as Delaware, and then pay a fee and taxes in the state in which you are doing business as well, such as Minnesota. Okay. Do you have to form an LLC? No way. There might be advantages to being a partnership, a limited partnership, a corporation, so forth. Okay, so which entity do you choose? It's really going to be based on how you want to manage your entity and also the tax consequences of those different choices. Okay, now, do you need a lawyer to do that? Experienced entrepreneurs may know exactly what they want to form. The actual forming is like pretty boring. Okay, it's just sort of a website thing. But getting to the determination, I see my fellow lawyers laughing. All right, but getting to the determination of what state you want to be in and what entity you might need some expert advice on that, unless you already know what you are doing, because like, especially, you know, for tax consequences and so forth, you don't want to screw that up. Okay. Let's see. So I'm going to then talk quickly about forming your buy-sell agreements. Okay, so remember, if you just have one owner, you can be a single member LLC. It's pretty great. It's one of the real advantages of the LLC system, that you can just be a single owner LLC. But if you have more than one owner, I would really encourage you to enter into an owner's agreement when you form your entity. Depending on what kind of entity that is, that might be called a shareholder's agreement. An operating agreement is the general term for LLCs, or you might see member control agreement, partnership agreement, if you're doing a limited liability partnership. In any case, that document is going to do a couple of really important things. One, it's going to document the agreement between the owners about how they're going to manage the business, how they're going to make decisions. Okay, is there one person who is the decision-making partner and one person who is kind of the silent money partner, okay, who goes to the lake and then gets the profits? Okay, you want to document that, Because if you don't document it, then under Minnesota law, you are considered to be equal partners with equal responsibilities and equal sharing in the profits. Okay, you can do a lot of things by contract, but you have to do them explicitly. And this is where you do it. Okay, you can tell that this is what I teach. I get really excited about this stuff. All right, the other thing that you want to make sure to do in that owner's agreement, shareholder agreement, LLC agreement, whatever, is to cover what we call buy-sell provisions. Okay, in other words, what happens to the equity if one of the owners dies, becomes disabled, or wants to leave the business? Okay, in some sense, a buy-sell agreement is like basically a prenup for your business among your co-owners, because it is actually pretty common to get into a business divorce situation. Okay, you no longer want to be partners, co-owners with this person. And if we can have a fair and graceful way for them to exit that we've developed at the beginning of the relationship, then we can avoid a lot of that risk of a really acrimonious and expensive business divorce on the back end. Okay, so some of the buy-sell agreements might, for instance, allow people to have their equity bought out by the company if they want to leave, or if someone is fired from the business, give the business a right to buy back their equity, okay, and allow them to exit. Again, we can do a lot of different things by contract, but we have to do it explicitly and we have to do it up front. Okay, so it's really smart to have those difficult decisions before you know who's going to exit and before you know how this relationship might potentially fall apart down the road. Okay, so can you do that without a lawyer? Well, I mean, in general, you could, right? I mean, it's really needing to document those difficult conversations and so forth. However, you do want to make sure to get it into the form that the law, finds binding, right? You will see, for instance, operating agreements for sale on Rocket Lawyer or so forth. They may not, however, document what you want your agreement to do. I have seen lots of situations where partners or LLC members entered into an agreement at the beginning of their relationship that they found on Rocket Lawyer, but nobody really read it. Nobody knows what it says, and that's not how they have been operating, right? That's a fail, okay? Because the law is going to look at what you have printed and signed, and then these other side agreements that you had orally, you're going to have to argue about whether or not that can come in if you get into a fight about it. Okay, so smart to enter into a document that reflects your agreements, and you may or may not be able to do that with a lawyer, but a little bit of help from a lawyer at the beginning to help you get it right can really save you a lot of headache down the road. Okay, that's my little piece. I want to hand it over to you, Brenna, to talk about how we set up equity in the company and what kind of things we should know.
Sure. Okay, so is anybody sweating because we mentioned equity? I know right from the get-go, when you start talking about giving away the farm, people get really, really nervous. And sometimes when we're nervous, we just don't want to think about it. And so it's okay. Think about it. And that's one thing that lawyers can help you with. If you don't want to think about it, I know it's hard to spend the money, but that's the biggest time that a lawyer can help you with that. And the main thing I want to really say about equity is that there's not just one way to do it. It depends on what entity you are. And oftentimes with these little LLCs, like Jen said, with little companies, I often recommend an LLC because it is so flexible. Pretty much what you want to contract for, you can contract for, and you can write it down and there you go. But for equity, when you're trying to decide what to do, there's not just one way. It's not one size fits all, especially now. You've probably heard of crowdfunding, Fundable. There's 18 different ones out there now, and they all set things up differently. Some use something called a SAFE agreement. That's a template for future equity that you feel like you can just grab off the shelf and go for it. That's another situation where maybe if you've done it before, that could work for you to, if you're familiar with it, to go through it, make sure it matches your situation perfectly, and away you go. The biggest thing, and this kind of echoes what I said before, but the biggest thing that I see people do wrong is not know what they're doing when it comes to equity. If an investor comes along and you're really excited, or maybe you're feeling a little bit desperate for cash and you just want to do anything they say, they send you some old agreement they've used that's 80 pages long, and maybe it's an equity incentive plan, and really you just want to give away common stock. And so it's a very different setup. It's a vesting schedule versus just a straight agreement for common, or maybe it's a future convertible note. Maybe these terms are scaring you. My biggest answer is just know what it is that you're doing. And as soon as someone says, a market cap or drag along, tag along, or one of these buzzwords that kind of freaks you out, lawyers are here to help you sift through that, and you don't need to sweat about it. And there are easier ways, especially if you're an LLC. If you do want to just sell, let's say, I always explain it as you're watching Shark Tank, and the terms are easy to understand, right? You want to give away 5% of the company for $100,000. If you want to just document that for common stock, a lawyer can help you do that too. Or sometimes maybe you could go into Rocket Lawyer and find the right template. And if you understand each and every term and everything you wanted to see is there, maybe you can do that too, as long as it works for both parties. But there are many ways to do it. There's tons of different structures, and you don't always have to give away the farm. I think another thing is to just think really creatively about what could work for people. Sometimes you can write in some kind of future promotion or partnership or services agreement. Even crowdfunding I've seen lately, especially in medical device. One of the companies I'm working with right now, it's on my LinkedIn if you want to learn about it, a little plug, but they have a really cool medical device they're needing to fundraise for the production of. And so they decided to start with crowdfunding. So with that, you literally are just raising money for your initiative. You're not giving away any equity. So you can kind of do things and see where you can end up before you necessarily have to, write off a third of your company or a quarter of your company. And then there's investors like my company that really do like to invest in startups. And of course, we want to come and bring our money and see what partnership we can do. But there are lots of options out there. I would say, before you start signing equity agreements, you probably want to talk to a lawyer that you trust. The worst thing I see is when no one's read the agreement on either side. So you want to just at least know what you're signing, know what you're getting into. Just recently, I told Jen about this previously, but I saw a situation where the zero was off in the units. And so instead of giving away 3%, they gave away 30%. And that had to be rectified. And of course, there was a plea to that person to please bump back down to 3%, and they did it and it worked out. But those are mistakes that you don't want to be just quickly making and finding out about later, when either you have the option for an exit or somebody else wants to come in and review your past paperwork and it's a mess. So it's worthwhile to get it right the first time, or at least if it's a mess right now, don't stress out. You can usually fix it, but it's worthwhile to make sure it's right. Sorry, I talked for so long.
No, that was terrific, Brenna. Thank you. Yes.
Sure.
Yeah. And actually on the paperwork note, it is common for us as startup lawyers to see entrepreneurs that have sort of started by going it alone. And one of the things that we help them do is like clean things up. For instance, if they have, leases that aren't in the entity, sign it. Oh, sorry, John, I don't want to steal your thunder. Okay, I'll let John talk more about maybe some of the contract cleanup that we can help with. But it is so good to get that stuff done before it becomes subject to a dispute, either among the founders or with a third party. Can get it cleaned up and approved and so forth. Okay, Nick, I'm going to hand it over to you to talk about IP.
All right, thank you. So IP can be kind of scary, but it also can be really powerful. I'm going to share my screen with you just to give you a little bit of information from the slides. So there's basically four different types of intellectual property that some people know about and others don't. The first one I'm going to talk about is copyright, and that's usually your written work, your photos, your film. Software is copyrighted, arts and design. And this is in your copyright, you'll these are an area that you maybe can do some on your own, because if you just self-publish and note that it's your copyrighted material, you will be able to have your copyright. You can also visit the Copyright Office, the U.S. Copyright Office, and you can register any type of written documents, photos, films, software, art designs there, and it will be archived for you. And you can even do it the old-fashioned way, where you could literally mail yourself something and just keep it in a sealed envelope. But it's important to think about this in terms of the internet, because people are publishing much more now, and so you have to think about it not only on protecting your own property and realizing the asset that your property is, but also you have to think about, especially when you're a startup, making sure that you don't infringe on other people's property. And so there's a combination of things you need to kind of look at a 360. So if I'm putting something on my website, for instance, where did I get that photo? Is that photo mine? Is it from a software that I got rights to, or is it just something I picked up on the internet? Because if it's owned by somebody else, you're probably going to get a letter saying you need to take that off because you're using that photo for commercial gain and it violates my copyright. And of course, that you have software. You've had software licenses. Some businesses will be showing films, or you'll even have background music. You're going to probably, if you're a restaurant or a bar, you're going to have to get a copyright license from one of the ASCAP or BMI. There's going to be several organizations. They'll probably contact you to get that license worked out. But if you don't have that, that's something that you're going to need to address. And that you probably don't need an attorney on a lot of those things, because you're going to feel comfortable and it's going to be straightforward agreements that a lot of times aren't even negotiable. But if you have more, if you're writing software, then you want to talk to an attorney. If that's your business. If you're a photographer, you probably want to make sure that you talk to an attorney to make sure you have your rights of how you're transferring the copyright to whoever you're selling it to or licensing it to. You'll have to get releases from the people you're working with, models, even sometimes if you're buildings, or if you're photographing a logo or something, all that has to be, we call it clearanced. You have to get license for those to be able to use it commercially. So that's the things to think about. So maybe you can do it yourself. Yeah, there's some issues there, but once it gets more complicated, and the more that it's at the heart of your business, the more you're going to want an attorney involved. The second one is trademark or trade dress. And that's the look and feel of your company, the company name that you're using commercially to name your product. And a lot of people are familiar with trademark. And a trademark can be registered at with the state, which the Secretary of State office, you can register a trademark. Typically people want to register it with the US Patent and Trademark Office to get federal protection. Once you start using commercially, there'll be some common law protection. So I think, when you look at the perspective of, do I need an attorney or not? This is an area that when you register it, you might not need an attorney, because you'll feel good about, maybe it's unique and distinctive, and you're using it in commerce. But you should think about, when you start to register it, you have to, and especially at the USPTO, you may have an interaction going back and forth. So they may say, no, you can't get it because it's not distinctive enough, or it's not unique, or it's descriptive of what you're selling. You can't get a trademark for shoes if you're selling shoes, for instance. So that's somewhere you might want to get an attorney if you're trying to be more aggressive in getting your trademark registered. Second, you might have to look again, flip it on the other side. Not only are you trying to protect your own property, but you also don't want to infringe on someone else's. So you want to do research to find out, the first thing to start is your search engines, Google's, Bing's, find out, who is there anyone else using this name? So usually I recommend using the most unique made up name if you can, like Google, Yahoo. You're thinking of these companies who have made up names, or something that's not really your product, like Apple or Alphabet. So there's opportunities there, but someone else might be using it. So you want to look at, your first line is investigation, but you can do on your own when coming up with these names and is just Googling it, or the second one is, I'll put all these on the next slide, but you go to the US Patent and Trademark Office and you can search the records. Everything is public if it's registered. And that's another one that some people don't necessarily think about, because someone can register a mark a year before they're going to use it, as long as they're going to use it within that year. And so someone may not be using it yet, but they may have reserved it. And you can reserve it if you are going to use it. So it's, again, so the more complicated it get and the more to the heart of your business it is, the more I recommend getting an attorney. The next one is patents. Everyone's probably heard of a patent, but I find that most people are confused by what a patent is, actually. So a patent is actually very difficult to get, because when you receive a patent from the USPTO, US Patent and Trademark Office, you have a monopoly on that sale for 20 years once it's granted. So it's a big asset to get it. But being that, because it's such an important asset, it's very difficult to get. So I recommend almost always getting a patent attorney, and they also have patent agents that are usually scientists or engineers who have taken the patent bar, and they will also be able to help you get a patent. If you're designing a product and you're saying, well, I probably can't get a patent because it's not new and innovative, also you should be thinking about, before you make too much investment into that product, you might want to find out if someone else has a patent on it. So you could probably do some searching on your own, again, for the same resources that I said.
Nick, I don't mean to interrupt, but we don't see your slides.
Oh, I'm sorry.
And I know they're very informative. Sorry to interrupt.
Okay, sorry. What are you seeing? Me?
Yes.
Okay, that's interesting. How about now?
Great.
Seeing them now?
Perfect.
Okay. And then finally, so patents, there's 3 different types of patents. Most of them are utility patents. That's what you're usually thinking of something that's mechanical, that is a device that works. The second one is the design patent, that are less used, but it has to be innovative to the point where it's new and not done before. So it's difficult to get a design patent. And then the final one that's really rare is a plant. You can get a patent on a plant if you create a new plant. And finally, the trade secrets. And this is where you probably will definitely want to get a lawyer involved, because a trade secret is a business secret protected from the public disclosure and through contract. And you have to be, in order to keep that intellectual property, you really need to have it buttoned down of protected and kept secret. So you want to have your employees sign non-disclosure agreements, non-competes. And so you really want to think about how you're going to do that and be very careful on how you protect it, because if you don't, you're going to lose that property right if it's leaked out. And this is usually done where you want to extend protection beyond the patent, because a patent you have to disclose publicly. So like the recipe for Coke, for instance, I think is one of the famous ones that is a notorious trade secret. They've protected it. If you work at Coke and you have access, you have to sign, your life away if you ever disclose it, so to speak. And also more relatable is customer lists are often trade secrets that people don't think about, because you've done all that work to create and call and nurture those customer lists. You don't want them to go out, and those are important assets. A couple of resources here that I mentioned that are available to you and it's public. For the state of Minnesota, it's easy. I think the Minnesota Secretary of State is is a great resource for any entrepreneur. I've used it as an entrepreneur. I recommend any new person who's looking into business. There's so many great resources there and explanations of how to do things. So I would check there for sure. The USPTO is another excellent resource. You can search all the publicly available information, and then of course the Copyright Office. I hope I didn't go too long. As an attorney, I'm going to tell you always get an attorney. But as an entrepreneur, I understand the limits of your resources sometimes. So I understand that there's things that you want to do on your own as well. And so I think it's important to make sure that you're doing the things that are going to be valuable to you, and don't skimp on things that are going to be really important to your assets, your business. I'm going to stop share.
Oh. Thank you so much, Nick. That was really helpful.
Thank you.
All right, John, let's hand it over to you.
Perfect. I'm going to share my contact information in the chat right now. All right. So it kind of works out for me to go last because I think everybody's probably figured out that my area touches everybody else's area. You've heard, at least unplanned, you heard everybody else talk about an agreement or a contract that's going to affect their specific area. And I'm going to try to make this entertaining because I know this is like the last 10 minutes of a class. And so I may have lost some of you already. So I'm going to try to get everybody back. All right. So contracts, the two types of contracts that we see a lot are, most people think of the first type, an external contract. So a commercial contract with a third party. But I kind of want to make a point of some of the most important contracts are the ones that are internal, which everybody has been talking about. Contracts with your co-founders, contracts at formation, contracts to protect your intellectual property like Nick talked about. And then the dreaded contracts that Brenna talked about that go with giving away your equity and making sure that you're tying that up and putting terms that are enforceable in place, even though you might have a handshake deal that looks a little bit different than the lawyer draws it up, probably about 15 pages less. But so I just want to kind of touch on a few things that are important in contracts. When we look at a contract for like the layperson drawing it up, usually we want to make sure that we're considering, most people can write a contract, right? And I think that there's a lot of different people that can put an agreement into writing. But some of the things that I see when we look at someone who's a layperson drawing up a contract is they maybe don't consider a few different things. And one of that would be the liability of someone when they enter into a contract. Like there potentially could be more liability than just what you were getting paid based on what you were doing. To give an example, if you are in technology, I work with a lot of tech companies, and you are going into someone's infrastructure, whether that's their website or their cloud or something of that nature, and you're creating a solution, you might not create a solution, and you might actually cause a problem. And so I think at the end of the day, you're like, well, you know, I'm just going to pull out. I'm not going to get paid. But what actually could happen if you don't have the right kind of contract is you might be responsible for any business interruption they have, loss of files, maybe even the disclosure of people's personal information, depending on what that company holds. So I think it's very important sometimes to the layperson who's writing a contract, not necessarily to be like, all right, I understand every word on this page, but to think about the things that may not be on that page and considerations that are a little bit outside of what the average person's looking at, and to kind of talk about a few of them and to kind of transition into when you should maybe look for an attorney. One of them is when you have like multi-members and you're looking at how are we going to form a business? What considerations are we going to think about? And Jen talked really great about one large consideration that I want everybody to think about when they're forming with another partner, and that's buy, sell, or, you know, death, disability, things that nobody's thinking about on the onset of a business. Or even the worst one, I think sometimes is, how am I going to remove this person? If this person starts not doing what they're supposed to do, or that, you know, they get arrested, and all of a sudden I have a 50% owner that isn't part of the business anymore. What do I do? And as I think Jen alluded to, sometimes if you don't have that explicitly in writing, it's tough to have a solution for that kind of situation. So I would recommend trying to engage an attorney on the onset. I know that kind of Nick said that I'm always going to tell you to hire an attorney, and that's probably the same thing I'm going to echo here. Is at the onset when you're looking at, all right, you can come up with an agreement with your founders. You can figure out how you're going to implement and innovate and, you know, change the world, as everybody says. But then when we get to actually launching the business and it comes to fruition and there's actually a business in place, I think it's a very good idea to sit down and engage an attorney who can put those different considerations and those founders handshake agreements into writing in an enforceable way, where you can look down the road if one of these, terrible instances that nobody wants to think about on the onset happen, then it's like, all right, we don't have to argue. Hey man, it's right here, or on paper. We can see on paper. All we have to do, it says go to section 32. There it is. There's the game plan. Instead of having a discussion like, all right, well, I don't really want to work with you anymore. What do we do now? Because the other person might be like, well, I want to own the company, and there's different considerations. If you have it hashed out at the onset, it's a very good situation to have. Another type of contract where I would encourage you to engage an attorney is if you're, Nick talked a lot about protecting your intellectual property. Sometimes you can't protect intellectual property. And what by that, I mean, if you have an idea that's not necessarily patentable, or it's not necessarily someone else, it's not a new idea to everybody else, but it could be a really good solution. And if you take it to market first, it can be a very lucrative idea. So the best way to protect that intellectual property is through contract. And when you have a contract like that, where your whole business depends on this intellectual property that you necessarily can't protect through like the USPTO office or through a different regulatory agency, I would encourage, when that business completely revolves around that trade secret or intellectual property, to engage an attorney and figure out the best way to tie it up. It will be a little bit of a cost at the front end, but it's a cost well spent if it's the entire foundation of your business, right? And then the last one to talk, those are two of the internal contracts that we kind of talk about. And to talk about an external one, I think that you can, as a layperson, be able to engage in a commercial contract with someone else in a couple scenarios. One, if it's just you, if you don't have another partner or someone that you're not significantly affecting, I think that you can be able to engage in some commercial contracts with other parties, as long as you have a good grasp on the terms that are being discussed. And another situation is if you're engaging like as a contractor for someone else who probably has legal counsel. I think that is another good time when you can engage in a commercial contract with a third party. I would still recommend having someone look over your contract with the person you're contracting with. But I think that's another time where you can maybe be able to do that on your own. And if you don't have money, it's always a great time to do it on your own, because that's kind of where you got to be. The best time to engage in an attorney, when you have a contract that is with a commercial contract with a third party, would be when you have a significant impact on the business that you're contracting with, or we're looking at a significant project that's going to take up your entire team's resources, whether that's money, employees' time. And just to give a few examples of why that is, when you have, everybody wants to hit the large contract and have this large annual recurring revenue for 5 years, and they want to, like, all right, I got the one client, I'm going to work on it for 10 years. But if you don't engage with someone who's got a little bit more expertise, there's questions that come up maybe down the road, like, all right, we've been doing this for 6 months. We don't really have much around what happens in termination. I don't really like your services, even though I said I was going to sign on for 5 years. We're done. And now you've completely put all your eggs into one basket without any kind of a return. So it's good to have someone who has a little bit of experience on figuring out, all right, what happens in the event of termination? Are you going to get paid out for a length of the contract? Are they not allowed to terminate within a certain period? Things of that nature. And another thing would be what I kind of alluded to before, is if you have a significant impact on that person's business, whether that's a business interruption, whether that's, oh my gosh, I just gave all of their files to the entire world because I'm in on their databases. In that case, there's a good value in having some type of either limitation on liability, or you can limit your liability to the point of where you're not having to pay for absolutely all the damage that you've done. But the way to do that is through a contract. So yeah, I think To talk a little bit about resources, I'm going to give not a traditional answer, but I think it's one of the ones that I've learned from a lot of entrepreneurs in the past. Is the resource, I think some of the best resources for people in the entrepreneurship community is to talk to the other founders, talk to people who've been through it, talk to other angel investors. And if you're lucky enough to have one of those angel investors who's exited in your corner, they're a board member investing in your company, I'd pick their mind. That's why they're there. They want you to be successful, or they don't want to invest in you. So I think that could be one of the greatest resources that you could do, is just sit down with someone who has the experience to do that. And I do want to talk about one common pitfall. This will be my last thing, but I'm encroaching on Brenna's area again here, but it's something that's come up a lot. And the understanding of what a friends and family round raise is not commonly known in the entrepreneurship community. A lot of people think that they can take money from friends and family, and it's like, oh, it's just free money. We don't need contracts. We don't need to worry about what we're doing. They're going to get like 5% down the road. We'll figure that out, though. I want people, whenever they are talking about anything that's equity or could be equity down the road, that should be what I call a 911, call an attorney who has experience in securities law. It can be a very detrimental thing down the road when you want to raise a lot more money. So that's a common pitfall I've seen a lot. And if you can protect yourself from that one, even if you're only raising people as small as like $25,000, you got to follow some rules. And I think it's very beneficial to at least know what they are. And maybe that money's not worth the risk. But I want
Yes. Oh, terrific point, John. Yes. The SEC does not care how much money you raised as to whether you are complying with laws. Unfortunately, yes. So I want to turn to the questions now, because we've got so many good questions in the chat. And the one I want to start with is, so we've had this whole conversation about when do you call an attorney, but like, what attorney do you call? I mean, I'll kick it off, folks, by saying attorneys are highly specialized. And I don't think that the general public fully understands that we're really as specialized, if not even more than doctors, right? And you wouldn't call a podiatrist a foot doctor if you were having a heart condition, and yet all of our cards just say attorney, right? So it's very confusing for everyone. So how do you find the startup attorney that you need, or the attorney that you need, you guys? Brenna, John, Nick, who wants to jump in here?
I can start. This is something I meant to mention because, as we all know, there are better and worse people in every profession, and there are people who have experience in certain areas and not others. I would say my best tip is to ask someone that you trust, rather than just Googling and trying to find someone, calling them up, and then going for it. Either ask another founder from your network. Ask an investor, because they've usually worked with many in your area. I've called my law school if I don't have someone in my network that has that specialty. A law school will probably help you. They always want to help their alum. So talk to someone that you trust. And then my second piece would be, feel free to interview them. You're going to pay them for their services. Don't feel intimidated. Most attorneys will give you a free consultation hour, or half hour, or whatever, phone call. Talk with them. If they don't click for you, it's just like finding a doctor that you like Jen said. If they don't click with you, move on and find another one, because you're going to be paying for it and it's important to your business.
I can hop in as well.
Please.
So I like 100% what Brenna said, and especially the last point. I think there are a lot of business attorneys and people who do a lot of startup work that are obviously experienced and know what they're doing. I think, like you said, if you can get a trusted referral, as long as you can get the baseline and figure out who's going to be a great fit from a expertise standpoint. But I think one of the biggest things for me, and most people who know me, I've got a very certain personality. You can be a personality fit with someone, or you're not. You may want a hands-on approach. You may want to have your attorney's number and be able to call them 6 times a day. Probably not me personally as the best fit if that's the case, but you want to have a personality fit and an expectation fit with an attorney who may be able to provide not only the expertise, but the amount of service, the amount of clarity that you want. The person who can break it down the best for you, maybe they use a lot more lay terms than the next person, but you want to be able to click with that person because like Brenna said, hopefully when you engage an attorney, you want to work with them down the road for a long time. It is very tough to go on the market and look for a new attorney every time you have a different legal problem. So I think vetting personality is very important.
Thanks, John. And let me just add one thing, especially as you get bigger, it can be helpful to have an attorney who is outside your company, but essentially or specifically operates as an outside general counsel. And that idea means they're the one you call, but then they're the one that has to figure out, you know, the specialty area that is needed for this specific question, right? We have a licensing issue with this regulatory authority. We have, you know, a possible litigation issue. They're going to be the one to have to farm out those issues to experts and then put them back into the context of knowing your business well. So that person can be a really trusted advisor and certainly cheaper as you grow than actually bringing in a general counsel who is your full-time employee. All right, Nick, if you have anything you want to add on that, please do. And then I would love for you to address some of the IP questions that we're seeing in the chat, because I have no idea.
Sure. I think this is one of the most important, especially if you're a startup and you're out there looking for money or looking for partners or looking for even contracts. You want to say, well, how do I protect that intellectual property? Like I said, there's just different categories of intellectual property that it may fit in, or it may not be protected under any of those. It's just a really good idea, like John had said. And the best way to do that is to contract. And there's a baseline, a non-disclosure agreement that you can probably find online. You've probably done that already, and you may have run that in with other businesses that you're working with. And those can be, they're essential, but they vary in effectiveness. So you want to make sure that you've got something that is going to hold up and that's going to be useful not only to you, but also make it attractive for someone to be able to partner or look at. Because some investors are going to say, well, you have a non-disclosure agreement, I'm not going to bother looking any further because I don't want to get in trouble. Or, there's obstacles that you want to make sure that you've kind of thought about when you're contracting those issues. Of course, if you registered something, you're going to have some protections there. But you also want to make sure when even if a lot of the contracts that John can talk to you about, is that you want to protect that property, saying, even you need to respect my property, like, if you're going to use my trademark only for these purposes, or, if you're going to use this language that I've wrote, a description of something, you can only use it here and here and here. Or if you're taking old software, you could do maybe an internal usage, but you can only do it with, you're going to limit your license to only 5 users, and you can't disclose it to your other contractors, or, so there's complications that you want to think about. Sometimes how do you want to control that relationship? And those are really important to think about when you're contracting. And that's where you may want to get an attorney involved, because all said and down the road, like, well, you gave me the software to use, so I just let everyone use it. And all of a sudden I shared it with my cousin down the road and his business, and they're using it. And you didn't say I couldn't, and all of a sudden someone's copying it, and they made a little tweak. But, so if you don't have protection on that, you could be in a place where, you did give them a license, even though you didn't really want to give them a license. So I think it's important. That's an area that you really want to think about getting an attorney involved. And as far as finding an attorney, it is difficult. I understand that. I've tried to do it myself, and I'm an attorney who has a network of people who I can call. And I think it is important to ask. I think it's always good to ask another attorney. And if they say me and you don't think that's their expertise, then probably ask somebody else. But usually the attorneys can refer you to somebody or get into their network of referrals, and that's going to be a really good source. But like any type of business relationship that you're obviously experienced at doing, if you're launching your business, it's really about having trust and connecting and making sure that you feel good about that relationship, because hopefully you can have one attorney that's going to develop with you along the way and meet those expectations.
Thanks, Nick. So Neela is telling me that it's okay that we're going a little bit into the end time so that we can answer the questions in the chat. So John, we had an interesting question from Igor. Can I lob that one to you?
Sure. I'm just making sure I answer the actual question here. I'm looking at it. Okay. Yeah. So kind of addressing protecting IP through contracts, which Nick just touched on as well, without having a patent. And I think Nick did a good job, but I want to hone in on a couple of things. He talked about like licensing the technology or trade secrets or proprietary in nature, and to give like, I like tacos, so I'm going to talk about like a taco truck. Let's say that someone comes up with a software that can locate all the food trucks that serve tacos in the Twin Cities. And they want to license that technology not only to like breweries or other facilities, but also to the taco trucks so people can find them. One big provision that I would like to be in there if I'm licensing out that technology is I don't want to offend developers, but I think that's a pretty easy concept to come up with. I don't think it's going to be patentable. There's a lot of other similar technologies out there. So we've got to protect it through contracts. So the biggest provision that I always want to include in some kind of a licensing contract like that, where you're giving someone your product and expecting a little bit of a return, is having them be a little exclusive with you. They want to have, a non-compete, so to speak, of, hey, you can't take my technology and go start your own company because they could see that you don't have a patent or you don't have anything to say they can't. So you have to do it contractually so you can protect yourself that way. The other one is if they may be running a taco truck, but running a software development company on the side, and they could re-engineer and redo your technology. And all of a sudden they don't technically infringe on the same thing that you're doing, but they're a little different as far as how the software works. I'm not going to try to act like I'm a techie and explain that because I don't know, but at that point, if they've re-engineered something that might technically not be the same thing, so you want to put in that contract, like you don't have the ability to re-engineer, redevelop. Essentially, you can't steal our idea and go use it for yourself. And so that's a good way to get people to use your technology, but not restrict them so hard with an NDA like Nick was talking about, where they don't even want to engage in you. Like, hey, you have the free reign to use this technology for these 10 things. We're going to get a return, but you can't do these 12 things because I have to protect myself. I want to have a product in 3 years. I don't want you to have my product in 3 years and I maybe made a little revenue.
And just to put a finer point on that, since I'm a law professor, so if we prohibit people from using our technology by agreement, will they obviously never use it and comply with the agreement 100%? No. So then what can we do? Sorry, this is my talk for one else. We can sue them, or we can threaten to sue them. Okay, that's what we can do as lawyers, right? So we also have to think about, like, are there damages, and what would, is that going to work well, and is that probably going to work well enough that seems like worth doing? All right.
Right. No, I left to point out, yes, it would be very important to have a liquidated damages clause, which explains, hey, if you do take my idea, this is exactly how much you're going to pay, so you don't have to fight it out in court as much. There's going to be a definite answer to that. Because it's going to be worth a certain amount. You want to have as many definitive answers as you can in that contract, so you don't have to leave it up to someone else to find out.
Thank you. All right, so Brenna, thank you for answering that question in chat. I appreciate it. I think that we have hit all of the questions in the chat. Does anybody else have anything that they want to lob at us? Oh, Brenna.
Oh, I just wanted to add one thing I forgot to say. In the realm of equity and investors, one of the biggest mistakes or kind of situations that I see companies get into is an investor came forward, they offered them 50 grand. That sounded exciting, so they took it. You don't have to work with an investor that makes your skin crawl, or that just isn't a good fit for your company, that you don't trust, that you think is a criminal, that you, whatever it is, you don't have to work with that investor. I know it can feel really desperate when you really need the money. But if you have a bad investor on your team, either that doesn't believe in the company or is in it for the wrong reasons or whatever, it can really damage your brand, your portfolio, your company down the road, and the things you want to do. So trust your investors. That was the last thing I wanted to say. You're worth it.
Because that's a long-term relationship. That's not just a one-off thing. Mm-hmm.
Yep.
Oh, thank you guys so much. All right. Any other questions? Let me hand it back to Neela. Thank you so much for the opportunity to have us all here, Neela.
Well, thank you. Really informative session. Was there any other questions from the attendees or any updates that you want to share with the group before we meet again next month? I have put a handful in our chat already. So please look at those. Is there anything else? Okay. Well, I don't want to be in your way from a long holiday weekend. So I just really want to thank our panelists, Nick and Brenna and John and Jen. Really informative session. Thank you for sharing your knowledge. Thanks to all of you for being part of it. And I hope you found the time together valuable. You learned something new, you made a new connection. And I hope you join us again next month on the fourth Friday for the Friday Forum. Be well, turn off your laptop this weekend, shut off your phone, have some respite during the holiday weekend. Thanks for joining us today. Be well.